Hello, and welcome to all of you out there. My name's Andy Leonetti. I'm a senior writer here at FindLaw.com, and I am very excited to be bringing back FindLaw's webinar series for 2022. Today, we have a very interesting topic that I know is still generating quite a bit of debate and conversation, and that's the subject of vaccine requirements at work. It's not something that most adults have ever had to think about before, but this issue is not going away anytime soon. And that's why we think we're going to have a great discussion today. And first off, I want to thank you, our audience, for submitting so many interesting, thoughtful questions for today's session. We're going to have a great discussion with our guest, who I will introduce in a minute. But first, just a little bit of housekeeping. After today's presentation or at any time, we just want to remind you that FindLaw.com is, and for the foreseeable future, will be your home for all things legal. You can find tens of thousands of legal articles and blog posts relevant to your needs and interests. And if you need a lawyer, perhaps an employment lawyer, actually, after today's discussion, we have the world's largest searchable directory of qualified local attorneys in your area. And just another note that after today's presentation, there will be a recording available both via a link and on YouTube. And now for the reason that you're all here today, we're joined by David Larson. He's a professor at the Hamline School of Law, a senior fellow at the Dispute Resolution Institute, and a member of the Health Law Institute, among numerous other positions. He's worked in the past at the Equal Employment Opportunity Commission in Washington, D.C., and participated in drafting regulations and interpretive guidance for the Americans with Disabilities Act. And when it comes to vaccines in the workplace, we know that this is a complex, quick-changing topic, and we're glad that we have such a noted employment law expert joining us today to impart a little bit of wisdom and knowledge here for you. So thank you for being with us today, Professor Larson.
Thank you.
Professor, I think I'd just like to start by reminding our listeners why we're still talking about this today, because it seems that the prevailing mood in the country is just that we're, quote, over this. But as far as we know, COVID-19 isn't over us yet. So with that, I will turn the floor over to you. Thank you.
Yeah, just to kind of pick up what we were saying right there, Andy, was that I'm here in Minnesota, and one of the leading national and worldwide experts is Michael Osterholm. And because he's at the University of Minnesota, epidemiologist expert, we hear him frequently on television and on radio, and Michael keeps reminding us that this isn't over, that we've seen mutations with the virus already, and it's likely we're going to see more mutations, and we never know how virulent those will be and how resistant to vaccines they'll be, and we have to stay vigilant in terms of what's happening around us. That's one reason why we're so concerned. So, but as this slide says, I've got the first few slides I've got are going to basically set a context to talking about vaccines, and I think we have to do. I've made over 230 presentations in 18 countries around the world, and I don't think I've ever made a presentation as challenging as this one, because things are so fluid. They're changing so quickly that I tried to wait to make this PowerPoint as late as I could. I made it on Sunday. And since then, things are already changing. They're changing, like, at this point, almost hourly. And an example of that is the state of Minnesota put on or the city of Minneapolis and St. Paul had a vaccine and a mask mandate for restaurants and bars. They put on January 19th. And literally just a couple hours ago, they decided to lift that mandate. So things are changing that quickly. They're changing by the hour. I put some statistics up here about cases and deaths. Look at the United States. I just put this up over the weekend for 902,182. I checked this morning. It's 912,549. So we've added $10,000 or 10,000 deaths since I put this slide together. So things are changing very quickly. And the other thing that complicates a discussion about this is, and I'll talk about the federal Biden administration attempt to have kind of a national rule about mandates and masks that was barred by the United States Supreme Court. So that leaves it with the states. And as we go around our country, we see so many differences between the states. And again in Minnesota. If I just go down to the southern border and walk into Iowa, I'm in a different world with some very different rules about vaccines and masks. And that makes it again a little challenging to talk about what are the rules and what are the rights and privileges when it comes to vaccines and masks and mandates. So yeah, it's really fluid. CBS News this morning just announced that Chinese scientists say they've perfected a 4-minute test that's as accurate as the PCR test. And as we know, the PCR test, the polymerase chain reaction test, is the most accurate, but it takes at least hours, sometimes days, to get those results. And now they're saying we've got one that can do it in 4 minutes. Well, if that's true, if they have a very, very accurate test that can give us results in 4 minutes, maybe this whole idea about having to demonstrate that you're vaccinated and need masks goes out the window, because now we know immediately whether you are infected or not, and we don't care whether you're vaccinated because we've got an accurate, very quick test. And that was just this morning. So that's how quickly things are changing, and we just have to keep adapting and paying really close attention. So this first slide, again, gives us why we're concerned about the coronavirus. It's not the only reason deaths. But there's all kinds of consequences from this pandemic. As you may recall, Delta Airlines told us a while back that when people were hospitalized, it was costing them $50,000 per hospitalization. And that's one reason they wanted to put in a vaccine mandate, because they didn't want their employees getting sick and going to hospitals. And if people don't want to get vaccinated, which raised the probability of being hospitalized, they don't want to have to pay $50,000 for every one of those individuals. So businesses, they have their own concerns. We know businesses have closed because they can't get healthy workers. That's another reason why some businesses have vaccine requirements. They want to make sure that people can stay healthy so they can provide the staffing that they need. So there's a myriad of reasons why we're concerned about the coronavirus and why we're concerned about these vaccine and mask mandates. Can I have the next slide? As I mentioned a minute ago, and this is what a number of health experts have talked about, is that the viruses mutate. Delta variant was twice as contagious as the original version of COVID-19. Now we're in this Omicron age, which pretty much has usurped the viral category. And when people are getting COVID now, it's Omicron. Omicron is much more contagious than Delta was. Mayo Clinic here in Minnesota tracks this very closely. I didn't know how many variants were out there. There's an example of what Mayo has been tracking and monitoring. We've got alpha, beta, gamma, epsilon, eta, iota, kappa, then a 1.617.3, mu, zeta. So there are lots of variants out there. They believe that Omicron is 2.7 to 3.7 times more infectious than Delta. So on the one hand, we know, at least so far, that it appears that Omicron is a little less dangerous when it comes to hospitalization risks than Delta was. But on the other hand, if a lot more people are getting infected, and more than 2 times, maybe 3 times, the fact that maybe it's only half as likely to go to the hospital still means, because more people are getting infected, that more people will be hospitalized. So just because it appears that it isn't as risky in terms of per person hospitalization risk, doesn't mean when we look collectively at the number of people that are being hospitalized that number is going down. And in fact, in many places it isn't going down. And if you listen to healthcare providers, they continue to say how exhausted they are trying to care for everybody coming in a lot of places. All our emergency rooms are full, and our long-term intensive care places are full. Omicron evades immunity better than Delta. It seems to be true. Well, if that's true, even if we have a high vaccination rate, we still may get people who are getting infected with the disease. The hope is that the vaccine, even if you might get infected, would prevent hospitalization, and that seems to be true. And it particularly seems to be true if people get the booster. If you get 2 shots of Pfizer, a Moderna, and then you get the 3rd booster, your hospitalization rate is very low. And last statistic I saw compared to unvaccinated, it's 97 times more likely you're going to end up in a hospital than somebody that has been double vaccinated and boosted. Next slide, please. But the situation's improving. Cases have declined from the peak January 15th. That's great. Almost everywhere. When I last checked a couple days ago, Maine was the only one that wasn't declining. There are variations within counties around the country. It seems to be in more of the rural counties that we're getting some acceleration that we're not seeing in more of the urban areas, but it's definitely good news. It's not clear that we've moved from the pandemic to endemic. And again, as health experts say, it's very much a shifting landscape. Next slide, please. Vaccines, according to CDC, best public health measure for protection. The primary series plus boosters is far and away the best protection. We still get some breakthrough infections, however, and that's one of the concerns about the mutations and the variants, is that are we going to end up with a variant and a mutation that really can evade the vaccines that we have now? We just don't know. Fully vaccinated, Mayo reports a few days ago, 63.9%, just about 64%, a little less than 2/3 of the country. Fully vaccinated was not taking into account boosters, so that's only the number that had gotten 2 shots so far. Next slide, please. Masks, even though we're going to focus on vaccines for the most part, they kind of go hand in hand. Masks and vaccines, those are the kinds of mandates you're seeing. It's safe to assume most people don't want to wear masks. I mean, masks aren't always that comfortable. And the fact is that the best masks are the ones that may be the least comfortable. The best masks are the ones that give you a good seal around your face. And that means under your eyes, along your cheeks. In order to do that, it's got to be sort of tight. And because it's going to be tight, it's going to be a little less comfortable. We now know that some of the cloth masks are not very helpful at all. People who are wearing bandanas, they might as well not. They're really doing almost nothing. Loosely woven cloth products provide very little protection. If it's multi-layered, it's a little bit better. The surgical masks are still better. The problem with those is that if you've worn those, you've seen people wearing them, they tend to gap along the cheeks. And any point in which that air can circulate in is going to be a problem, because the disease is transmitted through an aerosol, and if air can come in up beneath the eyes along the cheeks, you still can get infected. But certainly better than the cloth masks. You get your disposable surgical masks, KN95s. The best ones being the NIOSH approved respirators, N95s for a while. The guidance was don't get those because we really need them for the healthcare providers, but the production has been ramped up so much that we're at the stage at which they're pretty readily available. You can get N95 masks in a lot of different places and you can reuse them. Just have to be careful about how you're doing that. You take them off, let them sit in a bag or just by themselves for 3-4 days, and then you can just use them again. At some point, when they start getting dirty or tattered, you got to move on. But the key is fit closely on your face without gaps at the edges around the nose. Next slide, please. All right, so that's a lot of just general information that you may know already. But kind of the key, whenever you're talking about mandates, and we're going to talk primarily about the private sector, because most employers and employees are in the private sector, and most are non-unionized. If you follow unionization, you know that after World War II, the heyday of unions, we were over 40% of the private workforce was unionized. The world has changed. We're down to about 94%. Only about 6% of the workforce now in the private sector is unionized. So we're for almost everybody, we're in an at-will employment world where the employer sets the rules. And in an at-will employment world, arbitrary is fine. Arbitrary is fine unless there's some kind of express prohibition. What would be an express prohibition? For example, Title VII of the Civil Rights Act of 1964 that says you can't discriminate based upon race, color, religion, sex, or national origin. So if you're treating people differently based upon membership in one of those protected classes or based on that, you will have a problem in terms of legal liability. But if I want to dismiss somebody because they're wearing a Packers logo or pin, and growing up in Chicago, of course, that would be offensive to me as an employer, I could do that. I could just say, that's it, you're going home. I don't like Packers fans. And unless there was some other kind of disparate impact on a protected group that maybe the only Packers fans are women, so the only people I'm sending home are women, that then would be problematic. But as a general matter, I can think of a million reasons that are not going to be prohibited. So that's where we're starting. It's an at-will world. There are some common law exceptions: express or implied contract, tort or wrongful discharge, implied covenants, good faith and fair dealing. Those are some theories that courts have created to take away the harshness of arbitrary at-will employment rules. But again, they're exceptions. If you are unionized, you might have a collective bargaining. You will have a collective bargaining agreement. That's going to give you protections and grievance procedures. You can't be dismissed almost always for arbitrary reasons. There's usually a just cause dismissal protection in those agreements. That's probably one of the things that unions have failed at. One reason why their membership has gone down. They really haven't educated people that how vulnerable they are in a at-will employment world, and that through a collective bargaining agreement, they can get protected from at-will employment, and employers can be required to have business reasons for discharging, and that if you unionize, you're going to be much better off than an at-will employee. But people don't know that. People really don't understand how vulnerable they are. If you do have a collective bargaining agreement, you may have protections in there from arbitrary discharges. Next slide, please. And whenever we're talking about this world of vaccinations and people wanting to get vaccinated, not wanting to get vaccinated, I think we have to acknowledge the impact of social media. We're in a pandemic. It's stressful. It's hard. People are trying to educate their kids at home when they're trying to hold a full-time job. There's a lot of frustration, a lot of exhaustion. There's anger when fuses are short. People are saying, you know, I'm at my wit's end, and you're telling me something that I have to do that's going to make me uncomfortable. I don't have anything left, you know, and there's just no patience left. We're at a time of misinformation. We're living at a time that everybody has discovered that they can be micro multinationals. You go back half a century, you couldn't contact the world the way you can now. Through the internet and social media, the number of people you can communicate with is unprecedented. So we see all kinds of information going out and being distributed and retweeted and shared and reposted that simply is not accurate. And that sort of fuels this polarization we're seeing right now in terms of lots of different issues in our society. And I think we've evolved into this time where partisanship now equals patriotism. And for me, at least, that's regrettable. People believe that adhering as strongly as possible to their position is being patriotic. In my world, patriotism is an acknowledgement that sometimes you have to give up what you don't want to give up. Maybe you want a great Build Back Better plan that spends money like we've never spent before, but you're not going to get it. Yeah, so I think both the left and the right, however those are defined, have been a little too partisan. And that, I think, fuels some of the anger and frustration and the unwillingness to bend positions. Next slide, please. So let's get to some specific employment questions. And some of the questions that some of you And thank you for doing it. Submit it in advance. It's really helpful to me to know the kinds of things that are on your mind. So, can my employer require me to wear a mask or get a vaccine? Well, we go back to Atwill Employment. Employers can pretty much do whatever they want unless it's expressly prohibited. So we start by saying, yeah, you can do it. You can't discriminate based on membership in a protected class. You couldn't say, okay, only the women have to wear masks. Only the Jews have to wear masks. Only the Catholics have to wear masks. You can't do that kind of thing, but short of discriminating based upon membership in a protected class, yeah, you can. You can say wear a mask, get a vaccine. You can require only some workers to get a vaccine and wear a mask depending on what position they're in and what's their interaction with other workers. Could there be some kind of a disparate impact challenge? A disparate impact is when you have a facially neutral employment policy that has a disproportionate effect on membership in a protected class. It's hard to think about how that would happen here, but it's theoretically possible that maybe some mandate you have is falling disproportionately on a particular class because of maybe perhaps there's some segregation in your workforce and you've decided that everybody has to wear a mask or only this particular job category is at risk, ergo they're the ones that wear the masks. But it turns out that it's mostly women, it's mostly minorities. Maybe there's some reason, or maybe even just unconsciously, people have been placed in those positions. You might have a disproportionate impact on that group. It's so it's possible to make a statistical case that one of these mandates falls disproportionately on a protected class. Again, I think it's unlikely. And even if it happens, the employer wins the case if they can persuade us that there's a reason for doing it. If they can point out that this particular job category, they're working closely together, they're on an assembly line. There's some reason where we think that transmission is really easy. They can defend themselves. The employee in the circumstances does have an opportunity to come back and say, there's an alternative employment practice that's possible. You could have done something other than a mask mandate or other than a vaccine requirement. But again, the employee has the burden of persuading us that that alternative would have been as effective, would not have cost anymore. So I think the possibility of a successful disparate impact challenge to mask or vaccine mandates is unlikely. But we do have religious or disability-based exceptions. I'm going to talk more about those. So starting place, yes, employers in an at-will world can require mask vaccine mandates, but there are disability and religious-based exemptions. Next slide, please. Here's kind of an interesting angle. In the world of employment law, it's kind of separated. We have employment lawyers, then we have labor and union lawyers, management labor union lawyers. So when we think about the National Labor Relations Act, we think about unions and management and collective bargaining and labor relations. And we tend to think that that act only gives protection to people that are in unions. But if you read the act, that's not true. And the act says that basically protects anybody that engages in a concerted activity for mutual aid and protection. You don't need to have a labor union. All you need is that employees not acting alone. It can be just two people. So if you get two people together that say we don't want to abide by this vaccine mandate or mask mandate, well, that's concerted activity. Does that fall within the definition of mutual aid or protection? I think that's going to be a difficult case to make for most people, not looking at the exceptions, the exemptions. I think that generally a refusal to comply is not going to be for mutual aid and protection. But if you flip it over and you're talking about being concerned about going into a workplace because you don't think it's protective enough and you don't want to get sick yourself, or you have a vulnerable family member at home that you're really worried about bringing the infection back to, maybe you can request the employer to take some measures they're not taking now, because that sounds like it's for mutual aid and protection for everybody in your workforce. So that's, I think that's a kind of a creative angle in terms of what employees might be able to do to encourage an employer to take some protective measures. It's only a remedial statute. You're not going to get money. You're not going to get compensatory damages. No private right of action. So it's not, it's a weak statute, really, and you're not going to be able to force anybody to do a lot. But it's out there and it's a possibility. Next slide, please. All right, so this was really in the news recently. Did the Supreme Court ban employer vaccine and mask mandates in this U.S. Supreme Court decision where states were challenging the Biden administration to have a requirement that employers working for businesses with 100 or more employees must be vaccinated or submit to a weekly negative test and wear a mask indoors. And it was an emergency temporary standard. The OSHA Act allows for, in situations of grave danger, that they can institute emergency temporary standards. Well, a number of states got together and said that I don't think that OSHA has the power to do what's being attempted here. We think that this is an overreach. Supreme Court looked at it and said that, yeah, we agree. We think that what OSHA does, it regulates occupational safety, and we think that what they're doing here is really more of an attempt to regulate public health broadly, and that exceeds the power that Congress has given them. That we think that what you're requiring here is going to affect 84 million people, and that's beyond what Congress ever imagined you would be doing. At the same time, there was even a stricter rule for healthcare workers who work for entities that are funded by Medicare and Medicaid that receive that kind of funding. You had to be vaccinated. There was no testing alternative. And the court said, well, that stricter rule I think is okay. We think that given that the rule is limited to those entities that receive Medicare and Medicaid funding, now we have a really closer connection to the congressional grant of authority and the spending power of the federal government. And we think this is sufficiently closely tailored that we're going to uphold this 5-4 decision. It was close, but this rule is in effect. Next slide, please. So does this Supreme Court decision mean we'll never see government vaccine mask mandates again? No, I don't think so. They did not rule on the validity of the healthcare worker rule. The only question was whether the temporary injunctions that had been issued to block those rules should be enforced. Were they proper? It's a question about temporary injunctions and the probability of winning the case when you finally do litigate the merits. The OSHA case was sent back to the Sixth Circuit to decide on the merits whether to permanently block or uphold this emergency standard. So again, we didn't get a decision on the merits. OSHA then thought, well, we're probably not going to win on remand, so let's withdraw the rule. The fact that they withdrew the rule doesn't mean that the federal government cannot come back with another rule. It was only meant, even if it had been upheld, they only meant it to be in place for 6 months, and they were going to try and replace it with a more permanent standard. If you look at the U.S. Supreme Court decision that rejected the enforcement of this standard, the court suggested if you had a less indiscriminate rule that maybe wasn't so broad, that perhaps it could withstand challenge. But one of the concerns again is that we're not sure that OSHA is the proper entity to be promulgating and enforcing a rule like this, because we're not sure that its grant of power from Congress goes that far. And without a clear authorization from Congress, I think attempts from OSHA may not be successful. Next slide, please. Well, is OSHA the only government entity that we have to think about? Well, no, of course not. We have state, local, we have industry requirements, and they can go both ways. You can have state laws that are requiring vaccines and masks, but you can have state laws that are prohibiting employee vaccination mandates and mask mandates. We don't have a federal law in place, so right now it's not as though there's any federal preemption issues because that federal statute was rejected by the court. There's nothing there, and states have a lot of freedom to draft and implement their own rules regarding vaccines and masks. Next slide, please. So going back to that, the vaccine mandate that was upheld, so to receive Medicare and Medicaid funding, you must ensure that your staff, unless they're exempt from medical or religious reasons, are vaccinated. And again, this is a strict standard. You can't get out by tests, can't get out by just promising to wear masks. You got to be vaccinated. Now it's in effect in all 24 states that had issued preliminary injunctions to bar this mandate. Texas was not part of those cases. Court said Congress clearly did authorize the placing of these conditions on Medicare and Medicaid regulated facilities through its funding power. We believe the mandate is necessary to protect patient safety and health, and it, quote, fits neatly within the language of the authorizing statute, and it fits within the, quote, zone of reasonableness. Dissent took a tact not completely unlike in the previous case that we looked at, where they said that we don't know, we're not sure that requiring a medical procedure is within the power to administer funding. Again, we think this might be a bit of an overreach. You know, why do we come out this way? Well, I think that the risk to healthcare workers and the risk of transmission from a healthcare worker to a very vulnerable patient is so pressing that it's a little more sympathetic case for a court to say that this one resonates a little stronger than maybe the other one. We really understand that when somebody comes in and their immune system is already compromised, that for any number of reasons, maybe not COVID, could be anything, that if you had healthcare workers who are infected with a very transmissible disease or are working very closely with these individuals, there's a real risk to them. And so I think it was a little more sympathetic case for upholding this mandate when you think about the consequences and how easily the virus could be transmitted from healthcare workers to vulnerable patients. But anyway, we got these two Supreme Court decisions, one saying the mandate is thrown out, the other one saying we're going to uphold it. Next slide, please. When can an employee be forced to do something currently? Where does freedom of choice run into Atwill Employment? Was one of your questions. Well, welcome to America. In private employment, you have very limited choices. If you want, if you want more freedom of choice when it comes to employment, they might welcome you in Germany or Sweden or Western European country. Some state statutes, however, might offer protection. And this is kind of one of the things I said at the beginning of today, that we get a lot of variation around the country. And Florida is a good example of a state that's been pretty aggressive in terms of limiting the ability of businesses and schools to implement vaccine mandates and mask mandates. And that Florida statute there says that no vaccine mandates unless employees can opt out for medical reasons, sincerely held religious beliefs, COVID-19 immunity, whatever that means, periodic testing, use of employer-provided personal protective equipment. So no mandate unless you recognize all these exceptions. And if you don't comply with the statute, you're going to be fined $10,000. And if you have more than 100 employees, it could be $50,000. And I'll tell you what, even though we've caught you doing this, we're going to let you off the hook if you cure your violation and get rid of your requirement, and you reinstate and give back pay to anybody you fired for not complying. Next slide, please. Florida's unemployment insurance system is called a Reemployment Insurance. And in the Florida statute, termination based on failure to comply with a vaccination mandate is not considered misconduct, which generally is the standard for determining eligibility for reemployment and unemployment assistance. Florida calls it reemployment. So Florida has legislatively decreed that refusal to comply with the vaccine mandate is not the kind of misconduct that would take you out of unemployment assistance eligibility. So some places you can get unemployment compensation. Tort or wrongful discharge, can you bring a tort action? Tort of wrongful discharge is this tort theory that says that if there's a clear mandate of public policy, you can use that clear mandate of public policy to try and get tort damages. For example, if a school says that you'll get a speeding ticket if you go more than 25 miles per hour, somebody goes 50 miles per hour and hits you, you can't use that speeding statute to get monetary damages, but you can use a tort theory to say that that person acted unreasonably and by driving 50 miles per hour, and we know that because there's a clear mandate of public policy when the legislature or the city set the speed limit of 25 miles per hour. So therefore, I should recover money damages. I'm using the statute that doesn't provide money damages to me as a theory for saying that the employer acted so unreasonably and hurt me that I should be able to use a tort theory of recovery. Well, a statute that has government-imposed fines and allows for reinstatement, maybe it can provide a basis for a tort action, but also I think you'll run into the situation that because it does provide for reinstatement and back pay, that maybe a court would say that any common law action has been preempted by that legislation. There's no room for common law actions, and there's a remedy for the employees in the statute itself. Next slide, please. And then at the top of that, some states don't even recognize the tort. For example, Florida doesn't. So even though you might be able to think of how you could use a state statute to give you a tort action against an employer for discharging you or disciplining you for failing to comply with a vaccine mandate, it may be that your state doesn't even recognize the tort in the first place. And I think conservative states that prohibit mask mandates and write a statute about it are probably the same states that don't recognize this kind of creative tort of wrongful discharge. Next slide, please. So now that the mandate's gone, do you have any legal right to get your job back? You're still an Atwill employee. You still can be refused employment and terminated for not being vaccinated. If you're unvaccinated because of a religious belief or disability-based reason, however, then maybe you can. One question is whether or not the employer refused to provide a reasonable accommodation that would not cause an undue hardship. So we're going to look closely to see if what you're requesting is unreasonable, it creates an undue hardship, or your presence would create a direct threat. When we're talking about accommodating religion, it's a pretty low bar, because the idea is if I do a lot to accommodate your religious beliefs, I am establishing religion. The government's forcing me to establish religion, and that's a constitutional violation. So we're leery about pressing people too hard to accommodate religion because we're afraid that we will be establishing religions by doing that. So what an employer has to do to satisfy this undue hardship burden, it's a pretty low bar. It's regarded as de minimis. As long as you do something that's de minimis, it's okay. You're going to have to prove that you have a sincere religious belief or a protected disability. Next slide. So how do you prove this kind of stuff? Well, some states are making it easy for you because they don't want you to have to do it anyway. So Florida says if a private employers are prohibiting or private employers will be prohibited from mandating vaccines for employees without opportunity to obtain an exemption. And here's the exemptions that are available to you. And they're all hyperlinks there. And those hyperlinks take you to places where you can protect yourself from that mandate. And next slide, please. Okay, so I'm hoping you can look at this. So here's some examples. This is Florida's. This is what the state's giving to you. We don't like vaccination mandates so much that we're going to make it really easy for you to get out. So all you have to do is put your name in, your date of birth, some phone number, then say that I hereby declare that I have a religious belief. That's it. Sign it. Then the kind of important language I think is at the bottom of that form that says an employer can't inquire into the veracity of the employee's religious beliefs. This exemption statement requires the employer to allow the employee to opt out of any vaccination mandate. So it's pretty easy to get out of the mandates in Florida. You can't explore the veracity. Next slide, please. Their immunity exemption, once again, short form, just put in some name information, signature, then claim I have immunity based upon a negative PCR test, an antigen test, an antibody test. Keeping in mind that some of those tests are not particularly accurate at all. They have failure rates, the PCR test being the best one, but Florida is ready to accept any of them. And if you can produce evidence that you passed an antigen or antibody test with a negative result, that's all you need. And then again, this exemption is a blanket exemption. Employers have to accept it. Next slide, please. If you don't have a state form, however, what are you going to do? Well, employers can question whether you really have a religious belief, whether it's sincere. They'll look at your vaccination history. You say you don't want vaccinations. Let's see what you got in the past, because you probably had vaccinations in the past. You say you're religious. Do you go to church? What about the argument that I don't want a vaccination because fetal cells were used in research, testing, or production? And that's one argument that's been circulating the internet for a while now. Well, Conway Regional Health sent employees a list of 28 commonly used medicines that used fetal cells in research, testing, or production. And it includes Tylenol, Motrin, Tums, X-Lax, and said, have you never used any of these? You say you don't want to use this because of fetal cell, some kind of link somewhere far back in the research line. Have you ever used any of these? Next slide, please. And here's the actual form. It gets a little more specific than that. The list is long, and hopefully you can read that list and read it down. And my guess is that pretty much everybody here at least one time used something on this list. We're talking Benadryl, Sudafed, ibuprofen, Maalox. You know, it's kind of surprising how many over-the-counter medications can be traced back in some way or another to some kind of fetal tissue research. And you know, they basically say that to establish my sincerely held religious belief, I'm attesting that I've never taken any of these and that I never will. You know, can you attest to that? I certainly couldn't. But an employer can do that. They're basically testing the sincerity of your religious belief, whether you like it or not. I just think you have to admire it because it's pretty smart and pretty clever, and I think it's kind of airtight. So what they've done here in Conway Regional, I think their attorneys did a good job. Next slide, please. When it comes to accommodations, even if you can prove that you have a sincere religious belief, remember it's a low burden and the employer chooses the accommodation. Could be indefinite unpaid leave. It could be something you don't really like, but so long as it's reasonable, the employer chooses it. If it will create any kind of fundamental burden, fundamental alteration, or even a minimal burden, an employer may not have to do it. What if your religious leader declares that anybody in my congregation is exempt? That's probably not going to be helpful because it's a question of personal belief. Pope Francis said that getting the vaccination is a quote act of love. Next slide, please. EEOC has guidance, and I encourage you to take a look at it. It's it's very detailed. I think it's 32 pages, and it's been amended. They just added more pages in December, adding on a section N. One question is, can COVID bring you within the ADA because you now have an actual disability? If you have the kind of asymptomatic or flu-like symptoms, that would not give you the actual disability that brings you within the ADA to get ADA protection, but some people have long COVID. There's no bright line. So it's possible that a COVID infection could mean you are within the Americans with Disabilities Act because you have an actual disability. It's going to be individualized, fact-intensive inquiry. Next slide, please. Department of Justice has also provided guidance. Department of Justice deals with government services coming under Title II and public accommodations of businesses. Again, they're helping us to understand what's an actual disability. They're telling us that long COVID can be a physical or mental impairment, which it needs to be to fall under the ADA, and it can be a substantial limitation on a major life activity. And we don't need to significantly restrict a major life activity to fall within the Act. So it's entirely possible that long COVID itself can be the actual disability that brings you under the ADA and justifies a reasonable accommodation. Next slide, please. And that's it. So I kind of raced through.
Yeah, that's you covered a lot there, and thank you for that, Professor. But we have just a couple more questions that we've gotten from audience members that I'm going to hit you with here. And I think a very popular one, they all it falls along the line of, now that we live in a time of booster shot availability, I got my 2 shots, I complied. Now can my employer make me get a 3rd one?
Yeah, so after listening to me, I hope you are concluding that yes, the employer can. We, again, the same exemptions that may have protected you from the first 2 shots, the religious belief, the disability-based exemption. I mean, some people can't get a vaccination because they already have an immune compromised system, and there are people that just can't get vaccines, and they would be exempt from that requirement. But adding on the booster is not going to change the calculus at all. If you can give the 2, you can give. If you can require the 2, you can require the 3.
Okay. And so then the opposite side of that is someone who has done all 3 shots, but maybe their employer is not taking any mitigations, or they are, but they aren't actually enforcing them. What options does someone have there? Can someone request a work from home option if they're worried about, say, a vulnerable family member who lives at home with them?
Yeah. And just to kind of illustrate how complex things are, there's several layers to that question. I'll go to the last part first. Can you request a reasonable accommodation because you might have a spouse who is a high risk, maybe is diabetic, for example, maybe somebody who's pregnant. You might have kids that are less than 5 years old who have not been able to get vaccinated because it's not available to them, and you're really worried about bringing some infection home. Can you request to work at home because of your concern for a family member or a loved one? Generally, the answer to that is no, that the ADA does not require people to make reasonable accommodations so that you can protect someone with whom you have an association.
Okay.
And I'll jump back to the first step. And what about if you don't go back to work because you don't think they're taking enough precautions? They don't have any mask mandate. It's an assembly line, and you'll be standing right next to people, and you know because you've talked to each other, and there's people on that assembly line who aren't vaccinated and are never going to get vaccinated, and yet you're going to be standing right next to them, and that makes you very uncomfortable. So is there anything you can do? If you're high risk, you may be able to, as a reasonable accommodation, say that I can't work in this assignment because of my own personal risk. and you may be able to get an accommodation for yourself that way. OSHA says that employers have an obligation to provide a safe workplace. It could be that you could use that general duty clause from OSHA to encourage an employer to make certain kinds of changes. So I think there are possibilities to get alterations and accommodations at the workplace that may provide more protection for you. If you don't have a disability, the OSHA's argument is one you can make regardless of a disability. If you're going to do it as a request for an accommodation, you've got to be somebody that falls within the Act.
Okay. And speaking then of your right to know whether the coworker next to you on the assembly line is vaccinated or not, what actually, a lot of people have asked about what is still private with regard to their vaccination status or their coworker's vaccination status.
Yeah, I would think that if you're vaccinated and you believe in vaccinations, you would love to know if the person standing right next to you is vaccinated. Vaccinations are, I believe, medical examinations, and because they're medical examinations, we do have some confidentiality restrictions. I don't think that employers have the right to say that Tom, who works next to you, tested positive, so be careful. I don't think employers can do that, and that would be a violation of those confidentiality requirements under the ADA. What I think an employer could say is that somebody in the workplace, in your work department, has tested positive, and you may want to test yourself. You may seek medical advice and may end up having to quarantine. So to alert them that there's been a positive test from somebody, I think is fine. But if you're going to the extent of identifying individuals, then I think that's problematic.
Okay. And one more question for you is you've already talked about if your boss can require that you get tested. Can your boss require you to pay for those tests yourself?
Yeah, that's one of the things that was controversial about the Biden mandate. That also said that you could require vaccinations or testing, but it also said that the employer doesn't have to pay for the testing, and that raised a lot of concern because they said that, boy, OSHA's never done this before, implemented workplace standards, and then said the employer's got to pay for it. So there's a lot of pushback on that. I think the general understanding, I think the better position is that that testing and vaccine, the testing to see whether or not somebody is infected. The medical examination, and that employers
Okay. So we, right at the very end, as Professor Larson was asking his final question, we're still in a work from home world, and a lot of us, and Professor Larson's connection cut out, and And so
Well, I have reappeared for what it's
he's
worth.
back, and he's back to wrap up that final answer for our listeners.
Yeah. So when it comes to if you're going to require, for example, if you have a program that says get vaccinated, or you have to provide evidence of negative weekly tests, the Biden administration said employers would not have to pay for that. That was controversial. I think what the ADA would say is that that's a medical examination. If the employer is going to require that, the employer has to pay for that test. And I'll throw one other thing in. What if you lose your job because you refuse to take a vaccination? Can you get unemployment insurance? I think that's a really interesting question. I think most places would say that that's a personal choice, and that would fall under the broad definition of misconduct. And if the reason you lost your job is refusal to take a vaccine, you're not going to get workers' compensation. Looking again at that whole idea of variations, you've got Florida, and you've got Kansas, and you've got Tennessee, you've got Iowa, you've got some states that have come out in legislation that says termination for a refusal to abide by a mandate vaccination requirement is not misconduct, and you are qualified to collect unemployment insurance. And that's an express legislative intervention that again shows that 180-degree difference between some of our states.
Mm-hmm. Okay. Well, that's a great answer, and I think that's a great answer to close on. And thank you so much for joining us today, Professor Larson.
You're welcome. I enjoyed it. Thank you.
And a huge thank you to all of you out there for listening in today. And again, if you need to find a lawyer near you, you can head to lawyers.findlaw.com. And for more information about how COVID-19 and the law affects you, you can head to FindLaw.com/coronavirus laws for more information related to your specific situation. So look for an email from us soon containing a link to a recording of today's meeting. And then on that note, I will just say thank you for attending, and we will see you for our next webinar.